a suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
Indeed, David Whiting has sashayed into the studio and joins us now to take all your calls. Good morning.
Good morning, Ali.
Look, this is quite unusual, but I'm just going to let people know there are some spots on the talkback screen. So if you've got a legal question for David Whiting, this is your time. Mm-hmm. This is your chance. And I also just have to read a text. I was making a comment before the news, David, about wearing masks on public transport, and someone had sent me a photo of a sign on a tram that made it very clear that you had to wear a mask. And I said, well, you couldn't really miss it. It was at eye level. And someone has said, doesn't eye level depend on the height of a person? Of course it does. I should say I'm really short, and I reckon that even though it would have been above my eye level, I would have noticed this sign.
Okay.
Just thought I'd needed to point that out. Now, you don't have any homework.
No, homework free. Had the weekend
No,
off.
but you do
Yes.
have a bizarre story about...
Well, what I try and look for something that's a little bit interesting, and what I found is that there is a discussion on the internet about whether or not you can teach yoga in schools in Alabama. So you have 50 states in the United States of America all make their own weird rules, and in Alabama it's illegal to teach yoga. There's a suspicion that if you teach yoga in Alabama that it might lead you to convert to a particular religion, to Hindu, and therefore that's not to be allowed. So
can they teach meditation?
I'm not sure. But it's you just think how these things sneak in. It's been the law in Alabama since 1993. If it had been there since 1920s, okay, I can understand. But 1993, I thought we'd be a little bit more progressive than that. There was a suggestion 2 years ago that the law might be altered so that certain yoga poses could be taught.
Sorry, I shouldn't laugh, but
and that
wow.
failed. Right?
Yeah. So are there?
There's a certain lack of tolerance in Alabama.
Does Alabama have yoga studios, I wonder?
Not near schools, I would imagine.
No.
Yes.
Well, there you go. Well, you've succeeded in finding something that I would never have known if you hadn't drawn that to our attention.
Or cared about.
Or cared about, possibly.
Yes.
1300 222 774 is the number if you would like to talk to David Whiting. Jackie I'm assuming this is not quite finished, but I'm guessing you're in Bacchus Marsh. Hi, Jackie.
Yes.
Good.
Hello, Jackie.
What did you want to ask, David?
I live in a block of units, 3 of which are owners, and we have one group or one unit occupied by the son of a lady who died about 8 years ago.
Yes.
We're trying to get the legal side of these things tidied up because the title is still in her name.
Yes.
And that every time we apply to council to do something, we've spoken to the solicitors.
When you say you've spoken to the solicitors, Jackie, whose solicitors?
Our solicitors.
Oh, for the Owners Corporation.
That's
Jackie,
right.
I would talk to state trustees. Now, state trustees administer the estate of people who don't have anyone to administer their estate.
Right.
So you should be able to encourage state trustees to say, here's an estate which has not been administered for a period of 8 years.
Right.
And at which stage it may be that state trustees will say, well, all right, there doesn't appear to be an executor. We'll make an application to the Supreme Court to administer the estate. And that should deal with the issue at least in part, Jackie.
Thank you.
All right.
As far as we can find out, there's no will. And the other thing is the daughter now of one of these occupiers has moved in and seems to be managing the financial affairs, but she's schizophrenic, and that's causing chaos.
So, Jackie, it sounds to me like you do need to go to the people who can assist with any sorting of the will. I mean, it's hard when you're not actually part of the family that owns the property, I imagine, David.
Well, if you listen a little further to what Jackie said, is there's a lady died 8 years ago. Her son and her daughter are now living there. They might be the people who would inherit in any event.
But it hasn't been administered.
So it hasn't been administered, and in a sense there are no... It's almost like a victimless exercise. They are the people entitled to it. What Jackie does in terms of owners' corporation charges, I'm not sure. That could be a bit of a mess.
What happens in those situations more broadly, that if you know in a will that you are the beneficiary and someone dies and you move into the property, does it has to be formalised at some point? I mean, I suppose you have to have the name on the title.
What's the reason for you moving in? Are you the sole beneficiary? Is the property coming to you, or are you just one of many beneficiaries?
Interesting. Jackie, good luck with that. Motta in Glen Eira. Hello.
Oh, hello. David, my question is a fairly simple one. Under the Victorian Electoral Act 2002, if you elect to contest a fine for not voting in court, is it an offence of strict liability, or does the normal presumption of innocence apply?
I think you'll find it's an offence of strict liability.
So that makes it harder to make your case.
Well, I don't know what your case is.
A friend of mine was sent an apparent failure to vote notice. If you claim to have voted, you were supposed to put when, where and how, and she didn't take sufficient notice of the 3 items that they wanted. She just wrote, as a lot of other people did, I found out, I voted, with several exclamation marks and underlines. Apparently a lot of people...
Well, then what I would be doing is I would be writing to the prosecuting authority, who I imagine is the Electoral Office, and giving them the details. I mean,
yes, that's what they require.
Yes.
There is a provision, even after you've received an infringement notice, to apply for an internal review, and they have said that as long as you provide those 3 items, we'll waive the fine. But my question was, if they elected to fight it in court, would they have to prove that they voted, or would it be up to the prosecution to prove that they didn't?
Well, okay. Let's say you go to court and the prosecutor gets up and says the Victorian Electoral Office has no record of Motta's friend having voted. Right? And there's an affidavit or a declaration from someone who says, I have searched the records and I can find no reference to Motta's friend having voted. And we asked Motta's friend for details about where he or she voted, and that information was not forthcoming. Now, it's at that point your friend has the ability to say, I did vote. But it's at that stage it's then become he said, she said, whereas what you would logically have, you would be able to say, I went to the Glen Eira Primary School between 10 and 10:30 on that day and I voted. It starts to get you to the point where you're more likely to be believed. Otherwise, it just becomes a question of belief. So to turn around and say, I'm going to put you to your proofs, which is what you're saying to the Electoral Office, just creates a problem for you at the end, because you have the opportunity to subpoena the records for the local election and ask them to produce the records for that polling station.
Yes. Unfortunately, this was only by postal vote because of COVID, and she posted it in a pillar box, and they want to know where it was posted, not just how, but also where and when. And she can't remember precisely those details, but they said that if you provide approximate dates and times...
Yep, then that's what you do.
Yeah, you just have to do the best that you can. Motta, thank you for your call. John in Box Hill. Good morning, John.
Good morning, David and Ali. I've just another will issue, no surprise. I've been asked to fund a settlement from a beneficiary who's contested. No surprise, asset-rich, cash-poor estate. My question to you, David, is a deed of family arrangement sufficient to protect my investment from going astray, or do I need any other legal instruments in place? Example, a caveat by consent of the executor.
I'll answer your question and then give you a little bit more, John. If the deed of family arrangement makes it clear what your entitlement is as a result of your contribution and how and when you are to be paid, then there is an advantage for you. And if it's drawn properly and protects your interest, then it's fine. All right? if you're taking if the loan is to be secured in some way, then what you might put is a charging clause in the deed of family arrangement, so you can lodge a caveat over the property. Presumably, you're to be paid when the property's sold. So then if that's what that says and there's a charge, you can put a charge on it. Now, earlier this year, we got a call from a lady in Ballarat or somewhere else in regional Victoria who had a question where some 30 years ago, family members funded the grant of probate because the life tenant, the widow, had no money. And they've come along and said, look, we gave you all this money all these years ago to make this problem. Can we have our money back? And the solicitor who's advising the estate, I think unfairly, said, your claim statute barred. You should have made the claim within 6 years, at a point where nobody had any money. So what you do, Ali, is you put in the document when the money's to be repaid, and that's when your limitation period starts to run. So they're the things that you need to look at, John. Fairly straightforward. If you're to be paid upon the realisation of the property, then that's what you put in it. And if you're concerned, you put a caveat on it.
And is it beneficial to get the executor to agree to that on the document?
Well,
if
the executor agrees to the charging clause, I charge the estate's interest in this particular property with John's debt, then they've already agreed to the charge, and you can lodge a caveat.
All right, John, thank you. Rebecca in Blackburn, not a will query. Good morning, Rebecca.
Yeah, hi. I've received a fine for using my mobile phone while stopped at a traffic light.
Yes.
But I wasn't actually using it. It was hands-free, and I was making sure the cord was connected because it was going to die soon. And I've decided to contest it at court because I just want it as a learning experience what the rules are, because the same distractions if I'm reaching in next door to my handbag and getting something out while I'm stopped at the light.
You have a look at the road rules, Rebecca, about the use of mobile phones. So was it connected to a commercial docking station?
Yeah.
And you were just making sure that it was plugged in?
Yeah, I was mid-conversation talking to someone, and I just reached down to make sure the charging connection was still good because I knew it was going to die soon, and the police have pulled me over because they were next to me watching me.
Yes.
And it was an important call. And,
so, Rebecca, you need to look and see if there's a difference. I actually think there's a problem if you touch the phone.
Yes, I agree. I think it's you only have to touch the phone.
Yes. So, Rebecca, I will take the strict question on homework. I would suggest that you go to a magistrate's court other than the one that you're likely to appear in, and spend a morning just watching what happens in a magistrate's court and work out whether or not it's worth the investment.
Are you suggesting, David, that she might decide it? So, Rebecca, good luck with that. I do think, though, you're not even allowed to touch it. It's because you might only be, well, I shouldn't say only, you might be using the phone for directions, for example, and you can't even do that. You need to pull over and turn the car off to, if you're using it as a guidance.
It can't be in gear.
I thought it actually had to be off.
It's the transmission can't be engaged.
Oh, okay.
So you could pull over on the side of the
and idle
in a parking area, and you can take the car out of gear or put it in park, and that's okay. Right? So you can keep the air conditioning running.
Good point. Lee in Gippsland. Good morning, Lee.
Good morning.
Hi.
Hi. I've just got a question about aged care facilities and the people in the house that my parents are aged. Eventually they may need to go into aged care, one at a time or both at the same time. If it's one at a time, my understanding is the house is quarantined and does have to be sold.
Yes.
I have a foster sister who has lived, an intellectually disabled foster sister who has lived with them all her life. Where does she stand in her ability to stay in the house?
I think very limitedly. If it was round the other way, if it was a carer still in the house,
right.
But we're talking now about someone who is being cared for.
Well, she's at a level that she is actually helping them stay in the house. She can do a little bit of cooking and she does some cleaning.
Lee, I'm going to take that one on notice, so I've now got 2 lots of homework for next week.
All right, Lee.
It's a very precise question.
Yeah.
My view is that you get a period of time in which to resolve it, but I'll give you a much clearer answer next week.
Thank you, Lee. Make sure that you tune in next week. Jan in North Melbourne. Good morning, Jan.
Hello.
Hi.
I've got a bit of a long shot, I think. I live in an owners corporation, block of flats, and along our back border there is a row of about 6 or 8 plane trees, and they are enormous. Our flats are 4 stories, and they're twice as tall. The problem we have is that they're costing us a fortune.
Whose trees are they?
They belong to the owners corporations behind us. There are
Yes.
2 owners corporations that have them on their property. They're costing us a fortune in things like clearing pipes that have got a blockage from the roots.
Yes.
Gutters get filled all the time with the leaves from the plane trees.
Jan, your owners corporation could sue the other owners corporation to as a result of the damage being done to your property?
We can we?
Yes, so your owners corporation, because I imagine the trees are on common property over the back fence,
Yep.
and you turn around and you say to owners corporation number 2, they're your trees, I need you to deal with the consequences of your trees.
And what sort of options would that be? Would they perhaps have to pull them down or pay us something towards what we spend?
Well,
looking after
I would be. I mean, I looked. Well, I'm not a great fan of plane trees.
Me neither.
They do work very well from a anyway. So, why would you not ask them for a contribution to what it costs you
To
in
maintain
terms of
them.
looking after them? I
well,
rather like the
that-
ideas of the trees staying.
Yeah.
It's really a question of why should you be put to the cost because they have the trees.
Yeah, no, that would be my preference
Yes.
too. I just wasn't sure how practical that
All
was.
right.
Yeah, very practical.
Good luck, Jan. Ryan in Frankston. Good morning, Ryan.
Morning, guys. Thanks for having me on.
Far away.
I'm the owner of a 2-story unit, and my balcony has had leaks into the downstairs unit below me. We've had flood testing done, and they've come back and said, look, you can fix up the whole thing, which will cost about 5 figures, full re-waterproofing and testing with the tiles done. But the second option was just a reseal. And I was wondering, what's the liability if I do a reseal and eventually move out?
Well, your liability hasn't gone. Sorry. The problem you've got is water leaking to the downstairs property. If you stop the water leaking, then that's the end of it. But if in 2 years' time the seal breaks and your water starts leaking again, that's still your problem.
Even if he's made
But
taken
if
steps
you've
to repair
gone,
it.
yeah.
And if he's gone?
Well, Ali, if he's
It's not
fixed,
his problem
in
anymore.
a sense, he hasn't fixed the problem. He may well have paid a contractor to do the work, but if it doesn't solve the problem, then Ryan's still got a liability to his downstairs neighbour. There might also be an issue in relation to the Sale of Land Act, Ryan. If you know that the ceiling is wonky, you might have an obligation to tell a prospective purchaser that there are leakage problems from your balcony to the downstairs unit.
Yeah, okay.
All right, so my preference would be fix it properly.
Yeah, just a question though. If he does fix it properly, is he then obliged to tell any future buyer that has happened? Or if he's fixed it properly and he lives in it and it seems okay?
The legislation talks about you telling anything that you would have, well, the words I paraphrase are, what would you have liked to have known in buying the unit? Now,
Gee, that's loose.
It is, absolutely. It is, you could drive a truck through it because it doesn't depend on what David Whiting would want to know when he was buying, but or what Ali Moore wanted. Well, it's both very specific and very general. So it's what would Ali Moore herself want and what would a general purchaser want. You've got to actually cover both of it.
And then if you've purchased a property and you find that there's something there that the vendor knew about and didn't tell you about, and you didn't pick up, and you had a right to do a building inspection, for example. So
Well, let's take Ryan's problem.
But then does someone sue him?
Well, let's take Ryan's problem. He's not going to know. Sorry, a wonky seal on a patio or a balcony is not going to come up on any search that you do.
No, and he would have tried to fix it, and he wouldn't know.
Well, maybe
it was wonky.
Ryan, of course, would have tried to fix it, but somebody else might not have tried to fix it. If someone in Ryan's position chooses to not fix it, but just hopes he sells it on a sunny day, then he commits an offence under the Sale of Land Act but it has no impact on the contract. I've already settled. There's no damages claim. There's no, it's a kind of...
Wow.
So there's no comeback between the purchaser and the vendor. There's just an offence under the Sale of Land Act. So
So what happens? Who would enforce that offence?
The next issue is that the Fair Trading Act and consumer rights don't apply to a non-trader. So if I was to sell a unit with a leaking balcony and I don't tell anyone, the answer is the deceptive and misleading conduct provisions under the Fair Trading Act don't apply because I'm not a trader in those circumstances. So it's come along and say, yes, there's an offence there, but it's not particularly helpful as between vendor and purchaser.
No, but the bottom line is do the right thing.
Yes.
Do what you would, fix things like you would expect them to be fixed if you were staying in them. Kevin in Castlemaine. Hi, Kevin.
Yeah, hi, guys. Just a question, thanks, regarding VCAT. We previously had an issue with a guy we took to VCAT and came in our favour, and it was $17,000 worth, but he went belly up and we couldn't get any money out of him. We've now got a similar situation with a company that's still trading that owes our company about $5,000.
Yes.
But despite the VCAT ruling, they're still not paying. I'm just not sure what we should do.
The legal system fails on enforcement, Kevin. Fails almost absolutely. But certainly what you do is you transfer the judgment to the magistrate's court. You can do that online, and then you get a certificate of judgment from the magistrate's court which you can enforce.
How do you
I
enforce
can't
it, though?
promise. Well, you can send a bailiff round to seize the goods, and you get round there and they say, no, that particular company owns none of the assets on this property, and Kevin's got nowhere again. Or you can apply to wind the company up. But again, you're now putting good money after bad.
Yeah, like the company, I won't go into details of who they are, obviously, but they trade and they're a provider of a service.
Yes.
We provided a service to them.
Yep.
that they've refused to pay.
Oh, you put an ad in the local paper.
Well, you could sue them, couldn't you?
They have sued them, and he's got an order.
Yeah.
The question then is, what's enforcement? The usual enforcements are you go and you send the sheriff out, or you apply to wind them up.
Or you advertise if it's a service company.
Yes.
Darren in Ashwood. Hi, Darren. Oh, don't know what happened to Darren. We lost Darren there. We'll take one more call. Paul in Port Melbourne. Hi, Paul. Paul. Oh, dear. Paul.
Yeah, you're there.
Yep, I've
Sorry
got you.
about that.
No, that's not you. I think it was me. I take responsibility. Hi, Paul.
Following on from that discussion earlier about what happens when someone dies and there's a debt, if you were considering what you were going to do about your will, and if you had a child that was lending you lots of funds during your life, you just come up with some agreement and so that when when we both die, the child has the right to the proceeds of the house because we owe them X dollars, or is there something like that?
Well, what I do is I would put in your will something that says, as at today, I owe my son Paul $300,000, right? And I can intend to continue to borrow from him, and I acknowledge that liability, and he's to be repaid. The question becomes, though, if I'm giving him the house in lieu of the debt, is that fair to everybody else, or is that a different consideration?
Does he become like a preferred creditor in that
Well, he becomes a
situation?
creditor to the estate, so a beneficiary gets after the creditors are paid. So a couple of things. The other issue is that sometimes he might give you $5,000, he might give you an amount of money, that's not to be repaid. So I get situations where a parent is giving money to the child and we're dealing with it in the will, and we turn around and we say, well, all right, so I put in place a loan agreement to start with. Here's the loan agreement between you and me. There's an assumption that everything that my son or daughter gives me is by way of loan and not by way of gift. And that then starts in Paul's position to quantify what the liability is to be met when you die.
All right, thank you, Paul and David Whiting. Lovely to see
Thank you,
you
Ali.
again. Thank you very much. David Whiting there, Melbourne solicitor.